September 10, 2012. This is Justice Under Chief heading down to the courthouse to receive a decision. We had a hearing this morning where the matter was regarding the city of Fredericton and others who have filed a motion for security of costs, so that I would have to pay costs as security to basically guarantee that if the city won the appeal, there would be money sitting there for them to collect. Now this is unusual, and looking through Canley, I think there was only 12 decisions that were even remotely related to security costs, and very few of them were successful. This is it's natural that things follow their regular procedural course, which means that if one's unhappy with a decision in the lower courts, in this case the Court of Queen's Bench, someone can file an appeal, which I did, and we're moving through the appeal process. And instead of just allowing the appeal process to complete, the city of Fredericton has filed a motion back to the lower courts to have the same judge who heard the first couple motions and made a decision which is impugned, and I'm appealing because it's wrong on many levels. Instead of just having the appeal heard out, they're trying to, it seems to be a legal strategy to stop the appeal from being heard, or just cause me some financial difficulties by causing me to preemptively pay for failure, when in all realities my appeal is very likely to succeed. It's a terrible decision, and if I'm successful, I won't owe any costs whatsoever. And if I'm even more successful than just basically successful, I'll have costs reversed and awarded in my favor. So the city of Fredericton would have to pay me $7,000 in costs. So despite all that, it seems to me just a legal tactic to have to cause me to be in a position where I have to prepay costs. So here we go. We got a 1 o'clock time where the judge is going to render a decision. She appeared to have already made up her mind, but the last time I blogged about the fact that she heard a motion and rendered a decision within 10 minutes. That was about a 4-page decision, which was basically, it was not possible for her just to walk out, write the decision, and come back in. She had the decision prepared beforehand, and it basically didn't matter what I said at the hearing because she had her mind made up. Now, in this time, at this hearing today, it appears that she's trying to avoid that by taking a little bit longer to render a decision. After the decision, I'm going to post an interview, hopefully with some people who saw the proceedings, and I'll be providing an update video where I'll explain my position on the matter and where it stands at this time. It's worthy to note that it's very unusual for a judge to be reviewing something that she herself has already written, as in she gets to decide whether to grant this motion or not, and it's wrong that she's doing that, seeing as how this matter should just go to appeal, where a court of appeal court who is trained to review legal matters and decide whether there's any merit to the appeal or not. Instead, this matter is going back to the same judge who wrote a decision, so she's in quite the position. How can she say her first decision looks obviously bad and I'm likely to succeed on appeal, or on the other hand say her decision is just A-okay, it's all fine by her, seeing as how she wrote it in the first place? There's no possibility of there being a unbiased decision as an outcome to this matter. Well, here we are, the so-called Justice Building in Fredericton, New Brunswick. I'll let you know how it turns out. Thanks for listening. This is Justice Done Dirt Cheap in Fredericton, New Brunswick.